All right. Good afternoon, everyone. Thanks for joining us right at 1 o'clock. We're going to just wait a little bit. We have a few more attendees who said that they're going to join us, and we wanted to allow enough time for everybody to get connected and settled in. Hey, everyone. Thanks for joining us. Just a reminder, this is the Paid Leave Oregon Batch 14 rules, but we are just waiting a couple minutes to let a few more attendees join us. But we appreciate you all joining us this morning, or this afternoon, I should say. All right, welcome everyone. Today is Monday, November 17th, and it is 1:02 p.m. This is the first of two rulemaking public hearings for the Batch 14 Paid Leave Oregon proposed administrative rules related to benefits, equivalent plans, contributions, and appeals. This rulemaking hearing is now in session, and it is being recorded to create an official record. My name is Jacob Parpart, and I am a policy analyst here with Paid Leave Oregon. I will be serving as the hearings officer today for the Oregon Employment Department's public hearing on the proposed rulemaking for the Paid Leave Oregon program. Also with us today is Tiavan Sievers, the senior policy analyst here at Paid Leave Oregon. She will be leading up today's discussion. We have a few things to go over with you before we begin taking testimony, so I want to first thank you for your patience while we get through these, these first few things. First, the chat feature of this webinar will be used by our staff to provide links for you to use as a resource as we move through the hearing. Please look for those to show up as we move along. We will try to tell you when we're going to put links in, but in case we don't, know that they will be there for you in the chat feature. Additionally, if you're having technical issues, please use that chat feature to let us know. Everyone's microphones are currently deactivated except for OED staff, so this is the best way to inform us if you're having any technical issues. The question and answer feature is available to ask questions or to sign up to provide verbal testimony once we get to that point in the hearing. To sign up to speak, please add your name to the Q&A so that we know to call on you once the testimony period begins. We will call on you in the order that your name appears in the Q&A list, and this will also help us stay organized as we move throughout the hearing. If you have multiple rules that you would like to provide testimony on, you only need to put your name in the list once. However, if you've already shared and would like to share again later during the testimony period, you are welcome to add your name to the list again, and so that way we can call on you again. Lastly, we ask that you please provide respectful comments and questions during this public hearing. Our staff are working hard to continue improving this program, and we value your feedback. Today's public hearing is scheduled to run from 1 o'clock to 2:30 p.m. and we will be discussing the Batch 14 proposed administrative rule changes. We do plan to host a second public rulemaking hearing this coming Wednesday, November 19th, from 10 a.m. to 11:30. These hearings are scheduled for 1.5 hours. However, if there are limited public comments, questions, or testimonies, we may end up ending the hearing early. Along with the verbal feedback and comments we will be receiving today, we also accept written comments from the public. Written comments may be provided to the department by emailing the OED rules email inbox as written on the screen, rules@employ.oregon.gov. Please note that we are only accepting written comments through Friday, December 5th, with a cutoff time of 11:59 Pacific Standard Time. Any written comments provided on this batch of rules received after that time will not be reviewed or considered during this batch of rulemaking unless the department makes the decision to extend the public comment period for everyone. This rulemaking hearing is for the proposed permanent adoption of the Paid Leave Oregon Division's Batch 14 administrative rules. A link will be put into the chat where the public can provide written comment. Please note, this rulemaking hearing is not scheduled for individuals who have issues or other personal questions regarding unemployment insurance claims or paid leave Oregon claims, or any issues that are unrelated to the Batch 14 proposed administrative rules. If you need information about your specific unemployment claim or have unemployment insurance questions, please contact that program through their website at unemployment.oregon.gov. and use their contact us form. A link will be put in the chat for you. If you have questions regarding the Francis system, please call the number on the slide. We're also going to add that to the chat for you. If you are an employer or have questions regarding equivalent plans, you can use the Paid Leave Oregon contact number listed at the bottom of the current slide and by selecting the appropriate phone options. If you are an employer or have questions regarding Paid Leave Oregon contributions, you can use our contributions phone number listed on this slide and by selecting the appropriate phone options. Please note, our main goal is to gather comments during this public hearing regarding the Batch 14 rules. We will not be able to respond to any previous batches of rulemaking for Paid Leave Oregon, but if you do have questions or comments about previous batches or other permanent rules for the Oregon Employment Department, please email the rules inbox as seen on the screen, rules@employ.oregon.gov. And it's listed on the current slide, as I just said. After the public comment period closes, Paid Leave Oregon staff will review all testimony and questions and create a hearings officer report containing any responses that we may have. This report will be available on the department's rulemaking website after the permanent rules go into effect. Lastly, if you have any general questions or comments about the program, please feel free to send them through the Contact Us form on the Paid Leave Oregon website, paidleave.oregon.gov. At this time, I'm going to turn it over to Tiavan, who will give a high-level summary of the recent rulemaking regarding the administrative rules for Paid Leave Oregon, as well as a summary of the proposed rules that we are receiving comments on today. Tiavan, the floor is yours.
Thanks a lot, Jacob. So as mentioned, before we begin taking testimony on the proposed administrative rules, I'm going to give just a quick overview of the recent changes that Paid Leave has completed regarding our administrative rules. And so to summarize, our first 12 batches of administrative rules that you can see here on the slide, which total 121 rules, are all final. And in October, the department also filed a temporary administrative order with the Secretary of State's office, which we called Batch 13. This temporary filing consisted of 2 administrative rule amendments to rules relating to appeals. And those 2 temporary amendments are included with the batch of changes that we're discussing today. Batch 14, which we're receiving public comments on today, consists of 22 proposed administrative rule changes. These changes include 2 rule adoptions, 19 rule amendments, and 1 rule that is being repealed. The tentative timeline to have those rules become permanent is January 1st, 2026. I would like to point out that we also intended to receive public comment on one other rule, OAR 471-070-1300. This rule relates to the poster that employers post to advise employees about their rights and duties under paid leave Oregon. However, because of a filing error, the notice of proposed rulemaking did not include the language that we intended to amend, and we will therefore not include this rule in our permanent rule filing at the end of the year, and we will renotice it at a later date. So if you do not see it included today, that is why. At this point, all previously approved final rule language can be found on the Secretary of State's website. So I'm going to now quickly read aloud the administrative rule number, administrative rule title, and then provide a high-level summary of each of the batch 14 paid leave Oregon rules that we propose. And a link will be provided in the chat to the compilation of these rules. And I will read them off in numerical number and provide a summary. So you can see the first set of rules on the slide already. The first one is OAR 471-070-0001. For the purpose of the program, we are amending this rule to remove language which states that all paid leave Oregon rules are contained in Chapter 471, Division 70. This follows Senate Bill 69, which passed this year, which assigned rulemaking authority for oversight of job protections, retaliation, and discrimination related to paid leave Oregon to the Bureau of Labor and Industries, BOLI. The next rule that we're amending is OAR 471-070-1000, which relates to our benefits definition. This rule is being amended to add a definition for in loco parentis. It also clarifies, so to clarify how the term is applied under ORS 657B10. We're also updating the definition for average weekly wage. So the effective date aligns with the effective date that is also used by Oregon's unemployment insurance program. And finally, we're adding a definition for electronic signature. The next rule we're amending is OAR 471-070-1010, which relates to the eligibility and qualifications for benefits. We're amending this rule to clarify that pre-placement leave, so leave prior to foster care or adoption placement, is limited to 12 weeks per child, and that additional pregnancy leave can only be taken once per pregnancy, regardless of how many children a person carries. The next rule we're amending is OAR 471-070-1110. This relates to the verification of family leave to care for and bond with a child. The purpose of this amendment is to ensure that the verification requirements for bonding leave reflect the full range of legally recognized documents used to establish paternity or guardianship in Oregon. And we're also clarifying how a claimant may show an in loco parentis relationship with a child. And then finally, we're clarifying secondary documentation requirements that relate to the name of the child. The next rule we're amending is OAR 471-070-1120. This relates to the verification of a serious health condition. This rule amendment clarifies that verification documentation for serious health conditions must be signed by the patient's healthcare provider when the claimant is requesting leave to care for a family member. And it also updates the required information to include the patient's date of birth whenever it's different from the claimant's. The next rule we are amending is OAR 471-070-1130. This relates to the verification of safe leave. We are amending this rule to clarify that verification documentation for individuals who are claiming safe leave must include the name of the survivor or the name of the child if the child is the survivor. And we're also clarifying that secondary documentation is required to establish a family relationship when this relationship is not shown by the primary documentation. And finally, we're amending the rule to clarify how a claimant may show an in loco parentis relationship with a child, as also previously mentioned. The next rule we're amending is OAR 471-070-1250. This relates to the claimant designated representative. We're amending this rule to remove the provisions related to representation of incapacitated claimants because those sections will be moved to OAR 471-070-1260, which I will describe in a minute. And they will there be combined with provisions related to representation of deceased claimants. And so this follows the passing of Senate Bill 858 in the 2025 legislative session. And so moving on to that rule, OAR 471-070-1260, relating to the authorized agents of an incapacitated or deceased claimant. We're adopting this rule. This is a new rule to implement statutory changes made to ORS 657B-090 by the Senate Bill 858 I just mentioned, which authorizes representatives of incapacitated and deceased claimants to act on their behalf. And as required by that bill, this rule provides the requirements for designating an authorized agent, and it also establishes when an agent's authority ends. And as mentioned above, any existing provisions we had for agents of incapacitated claimants were moved to this new rule, and then the new provisions were added for agents of deceased claimants. Specifically, we're also describing that only individuals who are listed in ORS 293-490 may request to represent a deceased claimant, and this aligns with individuals who also may receive benefit payments following death. The next rule we're amending is OAR 471-070-1310. This relates to the communication to employers and employees. And I think maybe this application, I don't know if we had something stuck in here. Maybe that's just on my document. This rule is amended to remove language regarding the timing and frequency of the notice for consecutive and intermittent leave, as ORS 657B-040 doesn't currently give us any specific authority to describe requirements for different leave schedules. And we are also amending this rule to clarify that the employer must provide their policy and procedures regarding the notice to all employees, not only eligible employees. Moving on to the next rule, OAR 471-070-1330. This relates to job protections. And we're actually repealing this rule. And this is due to statutory changes that were made by Senate Bill 69, which I described above, which assigned rulemaking authority for oversight of job protections, retaliation, and discrimination related to paid leave Oregon to the Bureau of Labor and Industries. Moving on to the next rule, OAR 471-070-1350. This new rule relates to an active benefit year and benefit drawdown due to previous equivalent plan leave. And so this rule is being adopted to describe how Paid Leave Oregon acts when it receives information about a claimant's equivalent plan leave usage. So it describes how paid leave draws down benefits. An employee received benefits under an equivalent plan before applying for Paid Leave Oregon benefits. And this is to prevent an employee from exceeding the 12 or 14-week leave entitlement they have in a benefit year. The next rule we are amending is OAR 471-070-1450. This relates to benefit payment methods. In this rule, we are removing the specific reference to Relier Card Visa. The next rule we're amending is OAR 471-070-1465 for payments due to a deceased individual and abandoned payment. This is a very minor change. We're just removing an extra space in section 1. The next rule that is being amended is OAR 471-070-2210. This relates to equivalent plan application requirements and effective dates. This rule is being amended to fix an inaccuracy in the example regarding the due date of reapproval application. The next rule we're amending is OAR 471-070-2230. This relates to reporting requirements for equivalent plans. In this rule, we are updating the listed information that equivalent plan employers are required to provide on their aggregate benefit usage report. Moving on to the next rule. which is OAR 471-070-2330. This relates to the written notice poster to employees by equivalent plan providers. And the purpose of this amendment is to require that employers with approved equivalent plans update their notice poster if the department makes changes to the requirements that relate to the notice poster. The next rule amendment is to OAR 471-070-2460, and this relates to employer withdrawals of equivalent plans. We are amending this rule to clarify the timeline of when an equivalent plan withdrawal becomes effective. The next rule we're amending is OAR 471-070-3010. This relates to the method for determining the contribution rate and the maximum wage amount for paid leave Oregon. This rule is being amended to remove Section 3 because our statute, OARs 657B150, describes that the Social Security Index is used as the basis for adjusting the maximum wage amount. The next rule we're amending is OAR 471-070-30-100, and this relates to the localization of work. We are amending the title and also the rule language to align with statutory changes which were made to ORS 657B175 by Senate Bill 913 in the 2023 legislative session and to improve overall clarity. The next rule that we're proposing to amend is OAR 471-070-8000. This relates to appeals and the department's representation in hearings. This rule is being amended to comply with changes that were also made by Senate Bill 913 in the 2023 legislative session, as well as Senate Bill 858 in the 2025 session. And these were changes to ORS 657B410. And this rule also makes permanent temporary rule changes to remove the requirement that the Attorney General provides approval for the agency to represent itself in paid leave contested cases. The next rule that we're amending is OAR 471-070-8025 regarding late requests for hearing. And we're amending this rule to clarify that all late hearing requests will be referred to the Office of Hearings and Appeals for determination. And then finally, the last rule that we're proposing to amend is OAR 471-070-8050, which relates to the hearing for appeals. And this rule is being amended to align with, again, with changes made to ORS 657B410 following the passing of Senate Bill 913 in 2023 and Senate Bill 858 in 2025. As mentioned above, Senate Bill 858 authorizes representatives of incapacitated and deceased claimants to represent them in proceedings. And Senate Bill 913 directed the department to set a maximum amount the representative may charge and to describe rules or procedures a representative must follow. And then again, this rule also makes permanent temporary rule changes to remove the requirement that the Attorney General provides approval for the agency to represent itself in contested cases. So these are the 22 proposed administrative rule changes that we have for discussion today. And before I turn it back over to Jacob for the public testimony portion, I do want to thank you all for making the time today to provide your feedback and help us improve this program. We really appreciate it. And with that, back to you, Jacob.
Thank you, Tiavan, for the brief summaries of the draft rules, and good job. That was a lot of rules to get through, and you did excellent. Before we move on to the actual public testimony, I would like to I want to provide a few points I want to repeat before we get started on the public testimony itself. Number one, you can sign up for our bulletin and newsletter to receive updates on the Paid Leave Oregon program and learn when informational sessions are scheduled. A link providing how to sign up for bulletins and newsletters will be provided in the chat. Additionally, today's hearing and next hearing, this coming Wednesday, are scheduled so that Paid Leave Oregon and the Oregon Employment Department can receive comments regarding the Batch 14 proposed administrative rules. Any questions and comments related to unemployment insurance or specific unemployment claims should be sent to the UI program through their website, unemployment.oregon.gov, using the Contact Us form. And we'll add another link in the chat for you. Questions and comments about previous batches of Paid Leave Oregon administrative rules or the Paid Leave Oregon program itself or specific Paid Leave Oregon claims should be addressed to the Paid Leave's Contact Us form available on our website, paidleave.oregon.gov. And a link should also be posted in the chat to that website. If you would prefer to submit written comments about the rules today instead of verbally testifying, you are welcome to send written comments on the proposed rules to the rules@employ.oregon.gov email address as shown on the current slide. Please remember that the deadline to submit any written comments for this batch of rules is 11:59 p.m. Pacific Standard Time, Friday, December 5th. As we start the public comments portion, please add your name and rule number you wish to comment on to the question and answer chat. This will let us know that you want to submit verbal feedback during the hearing today. If you would like us to read your comment, we can do that as well. Please just write out your comment in the Q&A chat instead of adding your name. Otherwise, we will call names in the order they appear in the Q&A chat. We will get through as many comments as we can within the time frame today. It looks like we have about an hour and 4 minutes. And of course, if we start running out of questions and we have a long pause, we may end the hearing early. We will give people who want to provide verbal comments a few minutes to submit your name to the Q&A chat right now before we start calling on names. Once you have been identified and called on, we will enable your ability to unmute. For the record of the public hearing, please state your name and your preferred pronouns if you have one. If you represent an organization, please state which organization you are representing and which rule number or numbers you are providing comments on today. If you are providing comments on all or more than one of the batch 14 rules, please indicate as you change between each rule during your testimony. If your comments are not related to this batch of rules but are still related to administrative rules for Paid Leave Oregon, we ask that you actually please send your comments to the rules inbox as shown on the slide. Lastly, as mentioned earlier, if you have questions about Francis Online or the Paid Leave Oregon program, we encourage you to use one of the phone numbers listed on the slide to get more information. This hearing is specifically meant for receiving comments on the Batch 14 administrative rules, and we are unable to help with questions related to specific claims or personal situations. We'll now begin calling on you to provide your testimony for the record. Please keep your comments short and concise. We ask that you limit it to no longer than 3 minutes, just in case we have a long line of people who want to ask questions. If you have an interpreter with you, please let us know so we could also allow extra time to get everybody situated. Please note that if you have an extended testimony, we may bring up the 1 minute remaining slide to notify you that you are nearing the end of your time to speak. We appreciate your understanding and allowing everyone an opportunity to provide testimony. So with that being said, we're moving over to the public testimony portion of our hearing. I am not seeing any names in the Q&A. It does look like we do have one question in the chat. Can you include a link to all the rule changes so we can view them? And I think we already got that taken care of. Perfect. And so as we're waiting for any Q&As or any attendees to add their name to the Q&A or maybe any questions, we're just going to hang out for a moment, see if anything comes in. Again, though, before I mute myself for a few moments as we wait, I want to thank everybody for you attending today as we continue to improve the Paid Leave Oregon program. We appreciate all feedback. Thanks. Just as a reminder, this is the Paid Leave Oregon Batch 14 public rulemaking hearings. And we are currently at the public testimony portion of our hearing today. We don't have anybody waiting in the queue to have to share their testimony or have us read off their questions. However, we want to make sure and allow just a little bit of time for our attendees or anybody who may be joining us 30 minutes after the lunch hour. I know that sometimes people come late. We want to still provide an opportunity. So we're just going to keep hanging out. And like I said, if you have questions, please, or if you'd like to provide testimony, please add your name to the Q&A or let us know and we can identify you and and you can unmute yourself and ask your questions, or we can talk about your questions, or we can read off your questions for you. But again, we're just hanging out to see if anybody has any questions or testimony they'd like to provide. And it looks like we do actually have a question. It looks like it's written, so I'm going to go ahead and read it off. This was from Luby, Oregon, and with the Oregon Humane Society. And the question is, can you provide more specific information around Rule 471-070-1310? Employer must provide policy and procedures regarding notice to all employees, not only eligible employees.
Yeah, happy to elaborate on that a little bit. So basically, all it means is that the way it's currently written, it kind of sounds like if an employer has their own, written policy and procedures where they are describing, the requirements for the notice, that they must only provide it to employees who've already been found eligible for paid leave Oregon. But instead, they're supposed to provide it to all employees because it also informs whether an employee may then decide, okay, that I want to apply for paid leave Oregon, and then the program will determine if they're eligible. And so the way that was previously or is currently worded, it is just somewhat misleading. So an employer is just basically supposed to provide their policy to all employees, just to give them the possibility to be informed about the notice requirements.
Perfect. Thanks, Tiavan, for answering that question. In the meantime, we haven't had any other questions pop up, but as I mentioned earlier, we are hanging out for a bit to see if any questions about this batch of rules comes up. If it does, please feel free to add your name or your question to the Q&A section of this meeting, so that way we can identify either you or your question, and we can receive that and perhaps give you an answer. Thanks for hanging out with us this afternoon. All right, Tiavan, actually looks like we got a question in the chat from Jacob. And the question is, can we get a little bit more clarification to the rule change under 471-070-1310?
Yeah, and I guess one question for you, Jacob, if you can put this in the chat if you want. But I just spoke to the one change that we're making, so I'm just going to assume that you are clear on the eligible employee change. The other change that we're making to that rule is that we're removing any reference to notice requirements for consecutive or intermittent leave. So basically what that just means is we have a requirement in the program that an employee gives 30-day notice if their leave is foreseeable, and if their leave is not foreseeable, they must give notice orally within 24 hours and then follow that up with written notice after 3 days. But that is for all leave schedules. And we currently have some more specificity in our rule regarding what an employee should do specifically for consecutive or intermittent leave, because intermittent leave obviously is, not taken all in one chunk and they are separate days. And so we have some more specificity in the rule regarding that. However, we're removing that language, and we're removing it because we don't actually currently have the statutory authority to specifically speak to what an employee should do for intermittent leave days. And so if in order to be able to speak to that, that would require a statutory change. And so that's the reason for the other change to this rule. And yeah, and I had previously described already why we are taking out the word eligible. And I hope that clarifies this change.
So what does that mean practically for like so if an employee has got an open intermittent leave and then reports their intermittent date to their employer like 90 days late. What does that mean practically for the employer, and what does that mean practically for the Oregon constituent using paid leave Oregon? How would that administratively play out on either side?
Um,
I'm
so we we appreciate that this is a pain point for employers, because basically currently there are no requirements for an employee to specifically give notice for intermittent leave in a specific way. And so we obviously understand that employers must know when an employee is, taking a leave day. And so that is something that they should discuss with their employee. However, there are no legal requirements around this that we currently have, in statute. And therefore, there are also no repercussions if an employee does not give intermittent leave notice in a specific way. And so that is, again, I appreciate that as a pain point for employers, but because of the way our statute is currently written, we cannot be more specific around this. In terms of the administration, so as a program, we do not currently gather any information around intermittent leave notice from an employee. So when somebody applies for paid leave Oregon, we ask them, did you provide this notice to your employer, the initial notice? And so if they have not provided that notice as required, then their first leave of week of benefits, excuse me, can be reduced by 25%. But anything after that for intermittent leave days, we do not gather information around, whether notice was provided for intermittent leave days or not. So that's the status quo, basically. And I appreciate that from a practical standpoint, that is not a very satisfactory answer.
And Jacob, I still see, or I saw that you'd like to give public testimony on this. Are you wanting to give it verbally or written? I believe you still have the ability to speak. You still have
uh
the ability to unmute and mute. So
yeah, verbal works just fine.
feel free whenever you're ready.
Okay, so my name is Jacob Kierstead. I am not representing any employer, but rather an administrator within the industry. So this is my career. And the removal of the notification to the employer requirements, while I understand the legal reasons, which sounds like there is a good legal basis. It, however, creates a untenable situation to be able to provide employers with any clear guidance. It creates a number of history revisions. We all know that people's memory are really, really bad. And anyways, if you are in trouble and it's 6 months down the road, and that day that you otherwise took off to take your cat to the vet, and you're looking at, oh, I'm about to be written up, all of a sudden, it's like magic. It's paid leave Oregon. And you know what? That was my migraine time. Uh, it also creates a really horrible situation in which you will have the employer doing everything right, and then the employee, and you might end up terminating the employee. But you know what happens is then all of a sudden that employee then reports all those dates to paid leave Oregon, and now you've created a very large legal situation and a litigated situation, and that's completely and wholly unnecessary. This is a very standard policy and rule that employers set around all their leave programs. This is something that every single employer has. Like, hey, within 7 days, you've got to report this. Hey, within 24 hours, within 30 days. This is something that Oregon really needs to look at in adding that statutory language into the regulation. This is a horrible, horrible way to go about administrating a leave of absence program. This is not unemployment insurance. As much as Oregon likes to align paid leave Oregon with unemployment insurance, this is not unemployment. You can't treat it like unemployment insurance. And so anyways, we need to add that statutory language in there. And this is a very disappointing removal to otherwise keep a reasonability within the program. Thank you.
Yeah. Thank you for your testimony, Jacob. Appreciate it. All right. So we will continue waiting just a couple more minutes. I haven't seen, oh, there actually is a question. Apologize about that. There is a question from Zach, which asks, does that mean an employee can no call, no show up to 60 times in a year, provided they have an approved intermittent leave? And as an employer, we are not allowed to take disciplinary action. How do we define job abandonment if someone has an existing intermittent leave claim?
So I can speak to part of this question. In terms of the 60 times in a year, I just want to clarify how many intermittent leave days an employee can take in a year depends on their work schedule. So it's not always 60 days. And also employers may call paid leave Oregon and use the search function that we have implemented to look up and inquire how many days of intermittent leave an employee has already taken, and to kind of cross-check that with their own records in terms of what was reported to us and what we approved. So I just wanted to put that out there as like a practical tool. And so it's not always 60 days. However, in terms of not taking disciplinary action, as I mentioned before, BOLI, Bureau of Labor and Industries, is the agency that has the enforcement authority here and also now rulemaking authority. However, I believe that, because we cannot provide more specificity, it would be advisable for employers to be very cautious around disciplinary action. So yeah, that's all I can specifically say to that. Thank you.
Perfect. Thanks, Tiavan. Appreciate it. And thank you, Zach, for your question. Right. I am not seeing any more questions or names put in the chats, but we will hang out for a few more minutes and see if anything comes up. Again, we appreciate all of our attendees today joining us for the first of 2 public rulemaking hearings on the Paid Leave Oregon Batch 14 rules. And again, this is the public testimony, public comment time. So we're just gonna hang out and wait a little bit longer to see if we receive any names or questions in the chat for anybody who has questions or would like to provide public testimony. So I'm just going to note that there was an anonymous attendee who wanted to provide testimony that they agreed that BOLI needs to develop rules for employees to allow intermittent leave notifications to employers, as this is going to be a nightmare to manage. On the other side, there is a follow-up from Zach that says, sorry to keep harping on this, but does this mean there's no guidance on this if someone stops coming to work? I also understand 60 is the max. That is not the question.
So what I will just say, as I just mentioned, employers have the option to call Paid Leave Oregon or to use the employee search function. So if you have an employee that stops coming to work, you can cross-check whether they have filed weekly claims with us and have said that they have taken certain days as or marked them as taken paid leave, and whether paid leave approved or paid those days. So that's information that we can provide to employers. And so if you suspect that somebody may have just abandoned the job, that is information that we can provide. However, in terms of having given specific notice, we cannot, provide any more information about that at this time. And I also just wanted to tie back to the other comment that Jacob just read out, that also the Bureau of Labor and Industries is not able to adopt rules on this at this point without a statutory change, given that there is currently not that authority in our statute.
Thanks, Tiavan, and thank you everyone for your submissions of testimony and regarding this rule. As a reminder, this is the first of 2 public hearings for the Oregon Employment Department's Paid Leave Oregon Batch 14 administrative rule changes. At this time, we are accepting public testimony and comment. And so if you have any questions or comments, please feel free to submit either your name or the question itself to the Q&A feature. That helps us keep a record of all the questions that are submitted. And we can either call on you or we can read off your question, and it can be included with this public hearing that we are hosting. But we're going to hang out for a little bit longer and see if any more questions come in. Just want to, again, thank everybody for their testimonies and questions so far. We appreciate all the feedback that's provided, so that way we can continue improving paid leave Oregon. Looks like we did get another question in. This one's from Jacob. And Jacob asked, can I report absences from 2 years ago on a claim that I had open but never reported an individual date?
So if I understand the question correctly, no. So a weekly claim, an employee must submit a weekly claim within 30 days from the week that leave was taken. And so, if it's not reported within that time frame, it's considered late. There are some instances where good cause, can be present, but in that case, the employee would have to show that there was a good cause reason. And even that there, it would not happen 2 years later. So generally speaking, no, that's not something that could happen.
Perfect. Thanks, Tiavan, and thank you, Jacob, for the question regarding the reporting of leave. Tiavan, it looks like there's a follow-up question, wondering if Jacob thought that that we've removed the notice requirement.
So these are two different things. One is filing a weekly claim with Paid Leave Oregon, where somebody actually tells us, okay, I took intermittent leave on Monday, and then on Tuesday I worked, etc. So every week that they want to receive benefits for intermittent leave, they will have to file such an intermittent weekly claim, and that claim can only be filed within 30 days of the end of the week of leave that they're taking. And so that's one thing. And then the other is the notice to the employer. And so we have that initial notice that I described, which is, when you first apply for leave, that you have to provide notice to your employer. And then there's that section that we're removing, which regards to specific, leave days, intermittent leave days. And so that is what we're removing. So one is the notice to the employer, and one is the weekly claim requirement. And I also do want to stress that that initial notice, when somebody first applies for paid leave, that is still required. It's required by a statute. And we also are not changing that part in our administrative rule. It's really just relating to the specific intermittent leave requirements. That's the part that we are changing. So just to kind of distinguish these different requirements.
Thanks, Tiavan, and thanks for the follow-up question, Jacob. As a reminder, this is the first of two public hearings for the Paid Leave Oregon Batch 14 rules. This is the public testimony period. We are going to hang out just for a couple more minutes. There are a few questions trickling in here or there, but we also don't want to hold up anybody's time. So we may start leaning towards ending our hearing this afternoon. But we're going to hang out for a couple more minutes. So if you have any last questions, please get those submitted to the Q&A, whether you write out the question or you add your name, and we can provide you some time to provide verbal testimony. But thank you, everybody, for your attendance so far. We greatly appreciate all the feedback. All right, the time is now 1:57, and oh, actually, is there a paid leave Oregon contact? Is there a paid leave Oregon contact number for employers? If so, what is that? It's going to be the bottom number on the screen, which is 833-854-0166. You will need to select an appropriate phone option. I believe it's number 3. Don't quote me on it. But if you call that 833-854-0166 number, select the appropriate option. It'll say, for employers. That'll get you connected to our employer programs team, who are specialized in answering questions for employers. So, yeah. All right. With that being said, it's 1:58 now, and we're going to move towards closing our hearing today. We will be hosting a second public hearing this coming Wednesday at 10 a.m. You can register for the meeting on the OED Rulemaking website. We will add a link to the chat to our website for everyone. If you wish to provide written comments on these proposed permanent rules, you may also send us an email at rules@employ.oregon.gov, as seen on the bottom of the screen. And so with that being said, thank you everyone for attending the Oregon Employment Department's, Rulemaking Advisory Committee meeting for the Batch 14 Administrative Rules for Paid Leave Oregon. All feedback received today has been recorded to maintain the official record. This slide on your screen now shows where individuals can see the draft rules on the Oregon Employment Department's rulemaking webpage. We'll also add a link to the chat. Sorry, got lost in my script here. If you have general paid leave Oregon questions, please visit our Contact Us page on the paid leave website. That's paidleave.oregon.gov. If you have questions about individual claims or employer account details, please send us a web notice through your Francis Online account or give us a phone call. You can use that number on our screen. You may also email questions about the draft rules to the rules email inbox located located in the fourth bullet point on the screen. Paid Leave Oregon also has a web page that we keep up to date for employers, employees, self-employed individuals, or just interested parties. That's paidleave.oregon.gov. In addition to providing the comments today, anyone may email in written comments, as mentioned, to our rules inbox by Friday, December 5th at 11:59 p.m. Pacific Standard Time. Comments received after Friday, December 5th may not be reviewed or considered. And thank you all for attending the time out of your busy Monday and attending and participating in the Batch 14 Rulemaking Advisory or Batch 14 Rulemaking hearing. We really appreciate your interest and feedback. The time is now 2 p.m. on Monday, November 17th, and this public hearing, the first public hearing for the Batch 14 Paid Leave Oregon Administrative Rules, is officially closed. And we hope that everyone has a good day, and thanks for joining us.